Okay. War Room 2, aka what used to be the sewing room. It hasn't been a sewing room for how many years, people? Right? I'm going through all this paper looking for certain things. Some things I can find, some things I can't. That's what happens. No matter how hard you try and organize everything, after a while it just gets to be too much. Especially when you're always being stonewalled. And that's the reason why I'm doing this video, which maybe I should call it being stonewalled. Because tomorrow I'm going to the courthouse in Westminster. I'm going to try and avoid the Vancouver courthouse as much as I possibly can, if not altogether. Right? Just because. So anyway, I'm trying to deal with this 35-day pleading period. Hold on a minute. Okay, so the first thing I want to say is it's really extremely hard for me to see. Like you can't imagine, okay? Like it's just, my eyesight's just getting worse and worse and worse. But I'm going to try and work around it. So I'm going to the New Westminster Courthouse tomorrow to figure out what form I have to fill out in order to request a trial. I'm pretty sure that's what I did with Fraser Health. That was basically my only option other than to forfeit because they disagreed, right? That I'm just going on memory, okay? So I'm going through Fraser Health Authority's court papers. Remember when I told you that I signed a piece of paper where the judge was supposed to sign? Do you see that? And then that woman who pointed for me to sign there, and then they realized that it was a mistake. What do you call it? Followed me into the library and then had me sign something else. And then here you can see it's the same paper, right? Where it was signed. It's the same paper. Not that it makes much difference. They're allowed to make mistakes, but I'm not. So, okay. It all looks the same, people. So I got a little printout here. Right? With Fraser Health Authority. Court Service Online Judicial Module. View file details, documents. And this is with Fraser Health Authority. So on February 17th of 2017, that's when I registered the nonprofit, as if I have time to ever work on the nonprofit when it comes to paperwork, right? although I have to do that too. And I have to do Sierra's taxes. And there's still things that need to be dealt with Shmay stuff. Okay. So, I remember going with the girls. We filed them. Almost didn't happen because their system wouldn't print out my notice of civil claim because it was too much. So, anyway, long story short, it got filed at the Vancouver Registry on February 17th of 2017. Right? And then I must have served them, right? I think it was Tisha or Shmay, one of them, went to actual Fraser Health Authority head office here in some office up by the mall and served them personally. Okay? And then it says response to civil claim. I'm thinking that's my response. But it doesn't tell me what the response was in terms of what form. Because then it goes on to case plan proposal. Right? So the response to the civil claim was March 17th. So that was 30 days after I served Fraser Health Authority. Okay? I don't think it was their response to me. And if it was, I don't know, people. Anyway, it says response to civil claim, March 17th. Okay? I'm thinking that was my response to their response that they gave me. Okay? Because this is my file. This is not their file. Well, you would think all the documents that are being filed would go in here, right? So number 3 is notice of case planning conference. Okay? Which was done by Fraser Health. Now, I've attempted to try and do this, but obviously, I got distracted because my last contact with them was through the appeals. It was in February, and then Shmay died in April. Okay, I'm going to just jump with this, people, because this is how it is for me right now. Like I said, it all looks the same. I'm really, really struggling with this. Like, really struggling with this. You don't know how much I'm struggling with this. This is where that judge falsified his records. He kept going, yes, 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 but he took it out, and then he changed a couple of sentences in here. Of course, I can never prove that because I'm not the one with the audio, right? Let's just read this for the sake of reading it. Let's see how much it jogs my memory. Why not? Okay, in the Supreme Court of British Columbia, original, before the Honorable Mr. Justice Bowden, in chambers, appearing on her own behalf, counsel for the defendant. I appeared on my own behalf, and then we had Andrew the Dragon, right, representing Fraser Health Authority. Chorney versus Fraser Health Authority, page 2. 1. The court. This is an application by the defendant, the Fraser Health Authority, to strike the pleading and dismiss the claim of Judy Lynn Chorney in file number blah 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 regarding a notice of civil claim that was originally filed by Ms. Chorney in February of 2017. It is noted that the claim originally was over 175 pages in length. It has subsequently been reduced and is found in the applicant's binder at tab 7. The notice of civil claim now has been reduced to some 151 pages. No, I wrote it down to 19 pages, but I don't think I edited the last, relief sought and legal basis simply because, it didn't make sense to reduce those down. They wanted the gist of the material facts. Point is, people, is I did the best that I could. Number 3. Ms. Chorney alleges negligence on the part of the defendant in respect of the treatment and other aspects of their dealing with Mr. John Duncan. The claim also appears to allege some harm to her and my family. They didn't write that in there, though, did they? Not from any care to her, but perhaps from the care given to Mr. Duncan. But perhaps. Notice how they use that, right? Being elusive. As to her relationship to Mr. Duncan, Miss Chorney says she is like a daughter to Mr. Duncan, and they have been close friends for many years. Daughters are not friends, okay? Do you see how they imported that in there? I have documents in here where he's listed down as grandfather or stepfather. They list him down as a friend. Just like that pro bono lawyer that insulted me, right? And then they wonder why you don't want to go back to pro bono like that. In that instance where it's already pre-screened before you even get through the freaking door to sit down to talk to anybody about it. Back to this stonewalling. I'm just being flooded, remembering all the stonewalling that I went through. However, apparently Mr. Duncan has not been seen by Miss Chorney since about February of 2015, and she has not been able to find him. She says that his apparent disappearance has caused her and her family to be depressed. Miss Chorney says that at one time she had power of attorney. No, people, not at one time. I have never, ever been legally removed off of that account, which still exists in Andre's name and John's name and my name, and requires John's signature to sign it before we can take out the $92 that are in it, unless of course the bank has already closed the account and stole that money too, because it's been inactive. Miss Chorney says that at one time she had. No, I have. Power of attorney. I had 2. Enduring power of attorney and power of attorney. Regarding financial matters from Mr. Duncan, and it may or may not still be in force. But of course they weren't interested in investigating, because if they would have done that, they would have had to hold Fraser Health Authority to account to what they did to Uncle John, because the bank couldn't do what the bank did unless Fraser Health did what they did. They worked together as a team, people. This is where the next judge really needs to take the time to look at that information and give me time to bring in the correct. I mean, everything's all mixed up. Lots of it's organized to some degree, but when Shimei stuff came in, it kind of pushed out Uncle John's stuff. And, and not only that, but the times when I was going back and forth for those, 3 times in court and then trying to do the appeal, each time I photocopied new stuff, right? Because, you go, right? And you're being told that you have to hand in all this stuff, like, this, that, and blah, blah, blah. And you get there, they didn't even fucking take it, people. I was printing out stuff that was pointless because of what Fraser Health Authority's lawyer was doing to stonewall everything. And to, kick me off the freaking planet, man. She did not provide the court with the copy of the power of attorney. That's bullshit, people. That's bullshit. I came in, the judge took it, he looked at it in his hand. He goes, yeah, well, it could be, you need to follow up on that. Yeah. But that's with the bank. That's with the bank. That's what he told me, people. Fucking lying. Fucking lying, people. How do you protect yourself and your family against lies? Right? I gave him the original copy of John's will, for fuck's sakes. And the enduring power of attorney, right, from CIBC Bank that was printed out by the bank in terms of the one that was signed from 1990. Okay? They're lying. She did not. That's bullshit, people. As it was a power of attorney that related only to financial matters, it would not give her standing to proceed in court against Fraser Health Authority on his behalf. You see, that's the thing, though. That's how they were fucking me around when John was in that temporary. Oh, well, he's confused. Well, today he's not confused because he's going to do. But when he doesn't want to do what we tell him to do, all of a sudden he becomes confused. And then when they took him and I started dealing with the bank, they were flipping the script. Well, you can do this as long as you can go and get a letter from the doctor stating that he was confused, and then I phone back and say something, and oh well, no, it's actually if he wasn't confused, like in terms of they were just playing games, people. Like, the world is a bad place. It really is. I have 2 power of attorneys on that account. I gave the judge a photocopy of what the bank gave me from the original enduring power of attorney from 1990. Plus, I had a printout of another one that was stating me as power of attorney, since power, right? Enduring power of attorney is different than power of attorney, okay? From 2002, when the bank called us in, when we were living in Delta at Wally's house, 2001 or whatever it was, and they had John and I sign more papers for power of attorney, while the original enduring power of attorney stayed on his file and never went away, people. So this judge is lying. In my view, the plaintiff does not have standing to bring this action on behalf of Mr. Duncan, to the extent that her claim alleges a wrong done to Mr. Duncan. Yeah, he was medically kidnapped, people, illegally detained, and illegally drugged. And then he was illegally transported into an emergency situation where they kept him drugged for months, until finally they relocated him. But before that happened, they weren't too sure if he was going to die after they took him from point A, crossed over to the ferry, got onto the other side, and immediately rushed to the emergency room. Who the hell takes an old man that wants to go home, right, in a hammock, all drugged up, on the bows of a ferry, get to the other side, and when he wakes up and he realizes what the fuck is going on, what, they're just going to rush him off to the emergency in Victoria and say, look, this is how we found him? Yeah, you found him like that because you made him like that, people. He was in that temporary care ward for like over 40 fucking days before they did that to him. So if they found him like that, it was only because Fraser Health Authority was drugging him up and confusing him and messing up his fucking brain and making him sit in a dirty diaper all day long, every fucking day, for 40 fucking days straight. Right? But of course they don't want to investigate any of that now, do they? No. Now, because Uncle John wanted to be treated like that, in this judge's opinion. In my view, the plaintiff does not have standing to bring this action on behalf of Mr. Duncan, to the extent that her claim alleges a wrong done to Mr. Duncan. It is dismissed. In my view, even assuming the facts alleged are assumed, he didn't even bother to check, people. He had the power to call in an investigation. He had power, right? It's written in my lawsuit in that 175 pages. It's a specific something that a judge has power to do, and he just chose not to do it. Just keep reading. Oh, I lost myself here. I need to put my finger here. To the extent that her claim alleges a wrong done to Mr. Duncan, it is dismissed. In my view, right? Even assuming, right? The facts alleged are assumed to be true. Her claim would not succeed and is bound to fail, okay? We've been through that in other videos, right? To the extent that Miss Chorney's claim alleges wrongs to herself, to my family, people, to my children, people, the Fraser Health Authority does not owe any duty of care to her because she was not a person in their care or in the care of one of the hospitals within their authority. So therefore, they can commit crimes against other people and get away with it. Because when other people come to fight for the ones that are being destroyed by those ones that like to destroy lives, the ones that like to destroy lives make sure that those individuals have no one to stand up for them, fight for them, protect them, advocate for them. Just like all these hundreds of thousands of old people being locked away like health authorities' dirty secrets right across the freaking continent, with nobody being able to fight for them because they're not in the actual hospital setting themselves. While I sympathize with Miss Chorney's circumstances and understand that she misses Mr. Duncan, she would like to see him again. Her claim against Fraser Health Authority must be dismissed. In doing so, I have considered the submissions of the applicant and Miss Chorney, and in my view, it is plain and obvious that she claims that I discern from her notice of civil claim would fail, even if the alleged facts are assumed to be true. Right? So he made a decision without establishing any facts, people. He assumed I was guilty before proven innocent. In terms of, you lose. You don't even get a chance to try and win. Bottom line, that's being biased. That's a court being negligent and prejudiced against a poor person, okay? And bias. Which sets you up for more failure in life because they don't acknowledge the crimes that are going on in society. And that's why all these old people are locked up today and nobody can do shit about it. Because they shut up people like me, right? We wouldn't want this to get out into the public now, would we? The courthouse is fucking empty, people. When I went to the courthouse, I seen a total of 10 people walking. And the majority of those people were at their post. I only seen actually one person walk through the fucking halls. Only one person, people. Everybody else was behind plexiglass in the court registry, or they were at the front door drilling you as you were coming in through the door in terms of, do you have this symptom? Do you have this symptom? You can't go in until you answer these questions. Outside of that, there was only one person walking the fucking halls. Everything else was empty. What does that tell you, people? Not too many people in court now, is there? Why? And then he brings in some case law. What does the applicant say about costs? Mr. Buckley, my lord, we are seeking our costs in this matter, and I believe, or I submit, that we are entitled to do so. They've never given me a bill, people. Never. Not yet, anyway. As we were successful on our application. The court. Now, was it open to you before, Master Taylor, to seek the dismissal of the claim? Mr. Buckley. It was not put before Master Taylor, and I'm not aware whether that would be within the court. A master's jurisdiction. Mr. Buckley. A master's jurisdiction. And the reason it is before a judge's chambers today is the determination of duty of care, in my opinion, should be put before a judge, a determination on the law, the court. That could be, but I would, and I'm afraid I cannot say whether the master had jurisdiction. But if this could have been dismissed by the master, that would have saved the cost of this hearing. Now you have to remember, this hearing was in a whole room full of people waiting their turn to get their 10 minutes in front of a judge. Okay? Like, the room was full. Right? So there was no hearing. Right? We were supposed, that was the introduction to go. He was supposed to, I put an application in for a trial, people. They turned it into a 10-minute mini trial, dubbed me guilty, prosecuted me, and then fucking punished me. Okay? All in a matter of 15 minutes. With a room full of people waiting their turn for their 10 minutes of say. Okay? Judy Chorney. May I ask something? The court. Yes. Judy Chorney. I have on video where Mr. Duncan was asking for a lawyer 2 days before he went missing. 3 days before he went missing. I also have video of him doing a living will, but I already have his will from 1995, signed from Wally and Pam, my old landlords, to whom that I was at that house for 8 years, to which Pam is still alive. Wally ended up having an aneurysm, and Pam has to look after Wally for the rest of Wally's life now. But outside of that, I have Uncle John's will since 1995, people. That never changed until they changed it. Okay? Fraser Health Authority changed Uncle John's will. CIBC Bank changed Uncle John's will. And the Supreme Court of Canada in Vancouver, British Columbia, Canada changed Uncle John's will. Outside of that, I still have Uncle John's original will. So anything that we did online was only because we knew that something shady was up and we were getting kind of fucking scared. So we just wanted to put it out there, right? We just wanted it like you know, let's get back to, right? I also have video of him doing a living will, giving me power of attorney. I already had it, people. I had it through the bank. I still have it. It's never gone to court and been officially removed. I'm not going to go and face CIBC Bank by myself, knowing that they're just going to try and cover up Fraser Health Authority's fucking butt. And that's why I didn't go back. Okay? Right? Because it needs to be investigated by the government. Right? Because that's what's happening to these old people. Thousands of them. All across the continent. Okay? Tens of thousands. Probably hundreds of thousands of them, people. I also have video of him doing a living will, giving me power of attorney over his medical records and whatnot, and who he wanted to live with because of the duress that Fraser Health, the court, yes, the court. I am not going to continue with this case, ma'am. I made my decision. So I guess he cut me off. What I will say is that I think it is appropriate that costs only be awarded to the defendant up to, but not including, this application because of the uncertainty as to whether or not this matter could have been dealt with by Master Taylor, and in consideration of the fact that Miss Chorney is representing herself and does not have a lawyer. Judy Chorney. I represent Mr. Duncan, sir, and his family, his immediate family. My kids, Andre, Uncle John's immediate family. The court, you are the one bringing the action, ma'am, not Mr. Duncan. Well, how could he? He was drugged up in an emergency ward at the Victoria General Hospital, practically dying. Have that on tape, too. From his loving niece, who was too busy running around looking for her superannuation life insurance policy. That's how sick he was, as they kept him doped up so he'd sleep. Okay? And of course he had no advocate, right? Because when people are medically kidnapped, isn't that what happens? The court, you are the one bringing the action, ma'am, not Mr. Duncan. Judy Chorney, Mr. Duncan can't. He was illegally detained. The court, yes. Judy Chorney, he was illegally drugged. He was illegally transported. The court, all right. Judy Chorney, he was illegally. The court, all right. Judy Chorney, hijacked with all his finances and the court, fine. Judy Chorney, for some reason the court seems to think it's okay to cover that up. The court, no. So costs up to today, but not including today. All right. Judy Chorney, but I have the freedom to appeal. The court, absolutely, ma'am. Judy Chorney, I have the freedom to file another one. The court, you have the freedom to appeal this decision if you wish. He didn't say this shit, people, okay? He put this shit in there after the fucking fact, right? That's why I want to record, okay? Because he kept going, yes, yes, yes. Judy Chorney, and I have the freedom to file another lawsuit. He said, yes, but here he changed it and he wrote, that depends what the lawsuit relates to. Judy Chorney, okay. The court, there are rules regarding whether the matter is similar to this or different or a different matter. You may if you have a lawsuit on a different matter. He never said that, people. He never said that. He wrote that in after, in the wee hours of the morning, drinking. And he was sneaking around. Judy Chorney, no. The court, fine. Judy Chorney, Mr. Duncan is important. The court, all right. Judy Chorney, so is his immediate family. The court, all right. That's how it was dealt with when they dismissed it. Which Andrew the Dragon turned into a mini fucking trial. And then like I said, it all looks the same, people. It's really the paper is glaring. I can't even barely see. So okay. So that was, when was that? I have to organize everything. But you have to remember, Jamae got murdered. And then my life changed. And everything just got 10 times harder. And the responsibility became 100% harder. In terms of like 100 times harder. More than 100 times. So this was December 7th. reason for judgment. Okay? Order made by applicant. Notice of application. Affidavit. That's all Fraser Health Authority. Notice of civil claim part 1. Case plan order. Case plan proposal. Case plan proposal. Notice of case planning conference. I wanted a trial. They put in an application for a case conference. Anyway, what's this? Case plan order, Master Taylor. This was done on the 15th of August of 2017. That's where I got my little freebie with the amendment, right? He couldn't dismiss it, because when you ask to go to a trial, they can stall for time and say you need to amend. And then he said I had to bring my 175 plus pages down to no more than 20 pages, people. So I did that. I brought down it to basically 20 pages. But I didn't edit, scratch out the relief sought or the legal part of it, because I didn't know what I was doing, people. Like, I wasn't gonna, doing the first part, okay, I could understand, but doing the second part, it was plain as day in terms of what was written. But they used it as an excuse to do what they were doing, right? In terms of stonewalling. So anyway, at the case planning conference conducted on August 15th, 2017, before Master Taylor, in the presence of Judy Chorney on her own behalf, and Laurel something Wilson appearing as counsel for Fraser Health Authority, right? I guess Andrew wasn't there that day. On or before September 15th, the plaintiff shall file and serve an amended notice of civil claim. So what Judge Bowden there going on about that this guy should have dismissed it at that time, right? He couldn't, because that's what he said. He was obligated to give me that freebie, right? He was obligated. And that I should be grateful that I had it, basically, to do that amendment, to get it right, so that they could move forward, even though he knew in the back of his mind it was never going to move forward, right? Just stonewalling. Amended notice of civil claim, which scrutinally particularized the allegations against Fraser Health Authority and provides concise but sufficient material facts to support each allegation. 60 days after service of a properly amended notice of civil claim, the parties shall serve each other with their respective lists of documents. So technically, I don't really have to submit a list of documents tomorrow, because again, there's so much these are documents, people. Do I put everything by date, write out what each one is? I don't have to. These are documents, okay? This is stonewalling, right? This is the court being negligent and biased. Okay, negligent to Uncle John, who was a vulnerable elderly man who had his life completely destroyed because of the cover-up that's going on within our public union sector when it comes to criminal activity, right? The judge is culpable for that. That's why I don't feel bad filing another lawsuit, people, because at some point the courthouse has to become responsible for the misjustice that goes on in our society, because they're not doing their job, okay? I'm fighting back tears, telling myself to be strong. 60 days after service. And this was done in December. And I filed it in February. So a long time went without a document list. So it's possible. I just need to file the right form to get them into court so that I can get my freebie, that amendment, and then tell a judge, I don't think so, because whatever I do will never measure up to your expectations, right? Got that already documented, people. And that, we need to go to trial and the government needs to start pulling up some fucking files. And it would be in the best interest of the court to approve a legal aid lawyer to help with this matter so that it can be settled in a timely manner with a form of justice around it, right? Being that we're in a courthouse. Now, whether I get stonewalled or not remains to be seen, right? I'm trying to avoid the Vancouver courthouse altogether. Service of any documents in this action may be effected on the plaintiff by email. I'm not doing no email. It's like I don't want cell phones. Okay. So that was dated August 15th, I guess. (2017). And then, of course, it got dismissed. And then I tried to appeal. Okay? I tried to appeal. Okay? But I had to waive my fees, which I'm probably going to have to do again. It's going to take me a while to get everything organized. I just haven't had the time to do it. I can't find CIBC bank stuff. Don't know where that is. I can't find my tax. I got to do my taxes. I can't find my taxes. I can't find my tax forms or my slip. So anyway, this is a response. Court of Appeal. Dated February 21st, 2018. 2 months before Shmay died, basically. Right? Memorandum of argument of the respondent, Fraser Health Authority. Because I guess when you appeal, if I remember correctly, you have to let your opponent know that you're appealing, right? So they can come in and stonewall you. All right? And that's exactly what they did. They had me running around an appeal office saying I only had 7 pages to write, to put forward in front of the judge so that he would approve my waiver of fees, people. I never even got as far as to put my application in to go in front of a 3-panel judge because I had to waive the fees first before I could go in front of a judge to go in front of a 3-panel judge through an appeal process. But I had to waive my fees first because I wasn't paying the $200 up front. So I was going in to waive my fees. But for whatever reason, I was told I could write 7 pages, could take that 19 pages, bring it down to 7 pages, and then through that process, I was told I was no more allowed than 3 pages, have a video on that. So I'm like crunching, it's like crunching numbers. I get it down to basically 3 pages, but I had to lower the font. I had to make the font smaller to try and squeeze it all in, right? I get to court, right, with all my photocopies of my income and bills or whatever it was, right? Because in my mind, I'm just asking for a waiver of fees, people, so that I can go to the next stage and then put an application in to go in front of a judge to get approval for appeal, or however you, or like, right, however you do it. You can't do that until you get the waiver of fees. Well, along comes Andrew with his fucking binder like this thick. It was a lot of photocopy of what I got, right? Well, you know what I'm saying? And then he came in with another little file folder of all his funky case law, and he got it thrown out based on this memorandum of argument of the respondent, Fraser Health Authority. Overview: the appellant, okay? Applicant seeks no fee status. That's me, right? The respondent, Andrew the Dragon, Fraser Health Authority, opposes the appellant's application for no fee status on the basis that the appeal lacks merit. Right? What gives them the right to deny me access to a courthouse? Right? They denied me access to a courthouse, people. To an appeal board. Because, well, I suppose I could have refiled and paid the $200. But before I even had my head wrapped around everything, Schmay was dead. With CIBC Bank serving me on the day she died in the basement. To bring my butt to court with their little document list to cover their asses with what they were doing with Uncle John. And because they weren't acknowledging what Fraser Health Authority was doing, they would have gotten away with it. So, just never followed up on it, because as far as I'm concerned, it hasn't been settled. Just like, I don't know, these guys, they're just, right? You think they'd want to investigate CIBC Bank? You think that they would want to investigate what Fraser Health Authority did to Uncle John? But you see, they didn't care because they got his money. So what the fuck did they care what happened to him? As long as they got his money, their bank, that's all they cared about. The intended appeal arises from the order of Mr. Justice Bowden, made on December 7th. The intended appeal arises from the order, right? Striking the appellant's pleading and dismissing the appellant's claim against the respondent. And that's why you go to an appeal board, right? Because it got dismissed, right? But I wasn't afforded that right, was I? No. The applicant had not yet brought her appeal, is out of time to do so, and will need to bring a separate application to seek an extension of time. That's why I had it all written down to 3 pages. They ignored it. That's what I was told to do. First it was 7, then it went to 3. I did that, then they ignored it. On February 17, 2017, the applicant filed a notice of civil claim. This is the facts, right? Court of British Columbia, totaling over 175 pages. The claim related to health care rendered to a Mr. John Duncan while Mr. Duncan was admitted at facilities operated by respondent between January and February of 2015. Mr. Duncan was not a party to the action. Well, he couldn't have been because he was medically kidnapped and he was drugged up and hidden away like a dirty secret, right? And when the lawyer Paul was trying to contact him, they just weren't letting him speak to him. And he specifically said on video, people, that he was never told that Paul was trying to contact him, even though I have him on video with him telling me to go get Paul 2 days before he fucking disappeared. But of course they won't listen to that because that's too factual, right? Exhibit A to affidavit number 1, made February 20th. On September 15, 2017, pursuant to a case planning order, the applicant amended the claim to condense it to 20 pages. So, is that what I'm going to go to the courthouse tomorrow for? Is a case planning order? Who put that order in? Was it Fraser Health Authority that put that order in to overrule my request for a trial? Because I remember specifically filling out the paper where I requested 2 weeks or something like that, or whatever it was, for an actual trial to occur. And then somehow it turned into some case planning order where, right, they asked me to amend it down to 20 pages. But when we got to Justice Bowden, completely fucking ignored it. Exhibit C. And then December 7th, Mr. Justice Bowden heard the respondent's application to dismiss the claim the respondent applied in its notice of application to inter alia, I don't understand what that means, have the amended claim struck in its entirety pursuant to Rule 9.5 of the Supreme Court rules. Mr. Justice Bowden, on hearing counsel for the respondent as well as the appellant for herself, acceded to the respondent's application and ordered that the whole of the plaintiff's amended claim be struck out and the proceedings dismissed. So he sided with Fraser Health Authority, right? And denied me access to what is that called? Waiver of fees. And he sent me to the cops. Right? Told me to go to the cops and have the cops investigate what happened to Uncle John. Even though my son called the cops, right, when they wouldn't, right? I have that on video where the cops were saying, well, the social workers are just doing what social workers do best. Go get a lawyer. That's what the cop said. Go get a lawyer. Smack you in the face. Rub it in. Uncle John said, go get a lawyer, but they made it so that he couldn't have his lawyer. Mr. Justice Bowden held that it was plain and obvious that the claim was bound to fail. How did he determine that, people? He never even gave it a chance. At paragraph 6 and 7 of his oral reasons for judgment, Mr. Justice Bowden held that to the extent that the claim alleged wrongs to Mr. Duncan, by Fraser Health Authority, Ms. Chorney has no standing to bring the action on Mr. Duncan's behalf. Yeah, I do. He lived in my house for 23 years, people. Okay. All right. he was vulnerable. He depended on the family to help him through his old age. Okay? He had his life invested in his family. That's why they had to keep him locked up in a hospital, right, for months and months and months as they were figuring out how to steal his money. Okay? Under lock and key, being told he couldn't see the kids because he wasn't better yet. And he knew that. Further, to the extent that Miss Chorney claimed wrongs to herself following the care provided to me. Gang stalking is a big one, right? The targeting of my family was Shimei dying not even 2 months after the fact of this shit. She was a witness to a lot of this, people, a direct witness. They didn't want that. Fraser Health Authority had no duty to Miss Chorney, as she was not a patient of the Health Authority. That's the card they keep playing, right? As they ignored 2 powers of attorney and everything else written into the Notice of Civil Claim. Law and analysts. Indigent litigants. Despite anything in these rules, no fee is payable to the government by a person to commence, defend, or continue an appeal or application if a justice on application before or after the commencement of the appeal or application finds that the person is indigent unless the justice considers that the position being argued by the person lacks merit. This is how they justify it, right? Is scandalous. They're prejudiced before you even walk in through the fucking door. Frivolous or vexatious, or is otherwise an abuse of the process of the court. It was just a copy and paste of what they were doing in the courthouse in general. 8 lives have been ruined. FHA is misleading the court and acting in bad faith. This is just handwritten. Right, I just wrote a little something there, right? There are 2 factors that must be examined in determining whether indigent status should be granted. The likelihood of success. They prove you guilty before you even gone to a trial, people. Before you even had a chance to show the evidence. And even when you showed the evidence, I'm telling you, the judge looked at it and gave it back to me and ignored it. And then wrote in there that I didn't show him, which was a bunch of fucking crap. In terms of Uncle John's will and that power of attorney, right? Enduring power of attorney, too. 2 power of attorneys. That's why they couldn't. That's why they kept flipping from confused to unconfused to confused to unconfused, because both power of attorney relate to different things when it comes being confused or unconfused. So they had to cover both fucking bases, right? And that's why when Eleanor took over, she signed herself down as power of attorney and enduring power of attorney. She did it 2 times with the bank as the middleman. To remove me legally without going to court. I can prove all that if they would give me a chance. But they won't. Because they want to keep that status quo, because that's what they're doing with other people now. And because the families are not directly involved, they're not going to get the information like I have. Right? Indigenous status will not be granted in appeals that are bound to fail. So is this what I'm going to come up against? again. The appellant has the onus of providing that she has met the threshold test for indigent status. That means being poor. I came in with my financial statements. They completely ignored it. They didn't even look at it. They just were too busy trying to discredit anything that I had to say. The test cannot be met as the appeal has no merit. How would they know that? I never even got in front of an appeal board, people. An appeal is going in front of 3 judges. Okay? That was just to waiver my fees so that I can go in front of those 3 judges. They're the ones that are supposed to make that decision. So they dismissed my appeal, my waiver of fees. It wasn't even an appeal. They just dismissed it. They got it dismissed. It's a joke. The whole thing is a joke. One big fat fucking joke. No wonder why the courthouse is empty. And at the rate we're going, pretty soon we're not even going to need a courthouse. People are going to be so boxed in their worlds, right? None of this is going to matter. Anyway, it's all mixed up. I don't know what I have to file. I don't have a clue. I haven't found what I thought I was going to look for. Right? I mean, it's just like it's all over the place. I was supposed to do that over the winter, but it just didn't happen. And then, order to waive fees. You see? That's all I was trying to do. Right? Because you have to run around and fill out paper. Right? Affidavit in support of order to waive fees. I had to get the fees waived before I could go in front of the appeal judges. Because I didn't want to pay another $200. And they said I wasn't worthy of it. Which tells me that they're biased and they're prejudiced. So when I write it into the notice of civil claim with Shimei, and they're calling me fictitious and all this other shit, they're completely ignoring that fact. They speak with forked tongue. You can't say that you allow poor people to have access to a courthouse for justice when you simply deny them for being poor based on having no merit because they're poor, right? As they ignore everything that's pertinent. So this is like evidence. I don't know how to write it down. Hold on a minute. Okay, it's like going on 1:30 in the morning and I feel... I don't feel sick. I feel nauseated, people. Like, so nauseated with this paper. Like, seriously, man. So, I think I can't find CIBC stuff. It's just a little bit, right? Because you have to be up on this stuff, like, all the time. And not only that, but you need the table space and the shelving to be able to organize everything so it all, you know, when it gets moved around and, you know, I'm looking for something I know I can't find, And then what I'm looking for, I find some of it in a different bin that I obviously moved, right? Because I'm moving stuff around because I'm having to make way for Amari's wheelchair because he's getting too heavy. And that's another thing, people, you know, he's getting heavy, and like it's, you know, I'm getting a backache from it, and my feet are cramping up because like he's heavy. So as I'm carrying him, that's more weight on my feet. You know, my back is like getting sore because of his weight, right? On my feet pretty much all day, you know, dishes, laundry, yard cleaning, whatever, right? You know, so anyway, this is how I'm going to approach this problem. I found this page. Okay, this is not everything because I know I filed something. It was not a case plan proposal. It was a request for trial because I remember putting down X amount of days. But for whatever reason, I haven't been able to see a photocopy of that. So anytime you do stuff like this, before you submit it, always make sure you have a photocopy. And if you can't, get yourself a binder and start logging it in as you go. Otherwise, you end up like me. Okay? So, what I'm going to do tomorrow, I'm probably going to take a taxi now because this is too much to carry on a SkyTrain. I have to walk to the SkyTrain, walk to, you know, get on the SkyTrain, and then I'm just going to start piecing it tomorrow. They have tables in the library, right? So I can spread out the papers, and I should really bring my magnifying glass just in case. I don't know. But I'm going to take all this. Okay? This is just everything that basically occurred with Fraser Health Authority. And I'm just going to arrange it into dates for the most part. Right? I don't need this one. Court of Appeal. Now, whether everything is here remains to be seen. Waiver of fees. Right? Master Taylor. Honorable Justice Bowden. Notice of motion. Court of Appeal. Form 6. I don't even know if this was my application, I think, for an appeal. Reset no fee application. January 19th. Anyway, it's official. You can see that. So I'll just bring that with me. Without prejudice. It's an email that I received on September 25th, 2017. Says, we are in receipt of your amended notice of civil claim. Although the statement of facts has been condensed to approximately 20 pages, there are nearly 60 additional pages in Part 2 and 3 of your notice of civil claim which have not been amended. At the case planning conference on August 15, 2017, Master Taylor directed that your entire amendment notice of civil claim was to be no more than 15 to 20 pages, not just the statement of facts. You are in a violation of the direction of the court. In addition, the notice of civil claim as amended still discloses no reasonable claim. The allegations you raised against our client, Fraser Health Authority, are in relation to care and treatment received by Mr. John Duncan. Yeah, and it warrants an investigation. And then criminal charges against those who violated Uncle John and his immediate family for money. That's what they did. They violated him for money. Look what they did to Sierra as a comparison. They violated her too for her body. But she was homeless on the street and nobody really wanted her until it was time to harvest her body. Organs or whatever they got out of it. Because I'm still questioning as to whether she was really in that box, being that we weren't allowed to carry it. When it came time to bury it, you have to ask yourself, why weren't you allowed to carry your own daughter's casket? Like, people are fucked. Generally, a hospital owes a duty of care to its patients, not to the patient's friends or relatives. We believe that there is no basis in fact or law for your claim against the health authority. Yeah, Uncle John depended on me to stick up for him, people. That's why he stuck around me all those years. Accordingly, we have instructions to bring an application to strike your claim. If we are forced to bring this application, we will be seeking a cost award against you. If, however, you agree to drop this action, I'm getting tired, right? And plus I don't feel very well. I really don't. This stuff makes me nauseated. But that's, I'm going to take it all with me tomorrow. I'm just going to spread it out on the table. And I'm going to figure out what I have to do next. One way or another. And while I'm doing that, I'm going to put this all into dated order. Because this is evidence, right? Only I don't know how to list it down on the evidence sheet. Which just makes me want to cry. If, however, you agree to drop this action before we bring the application, our client is willing to waive the costs it has incurred to date in defending this claim. Well, as far as I'm concerned, their client harvests organs illegally and sells them on the black market to something or somebody and make profit. Okay, people? And if they're not doing that, they're going after the ones with the money, and they're making sure that those individuals like Uncle John don't have a voice and are isolated and basically annihilated to the point where they have meaningless lives locked up like a dirty secret. That is my opinion. That is my experience. That is my claim. Therefore, in full and final settlement of this claim, we are instructed to offer you a waiver of costs in exchange for your agreement to sign a consent order dismissing this action, which I never did, people. I tried to get a waiver of fees so that I could put in an application to go in front of a 3-panel appeal judge for a trial. I was just fighting for a trial so that I could bring forward the evidence in a timely manner and prove the criminal activity that was going on at that time. Waiver of costs in exchange for your agreement to sign a consent order dismissing this action, and a release stating that you will not bring further claims against Fraser Health Authority in relation to this matter. So they also wanted me to agree to not bringing any more further claims to them. I didn't sign anything, people. Our offer will remain open until 4 p.m. on Friday, October 6, 2017, at which time it will be rescinded. The defendant reserves its right to bring this offer to the attention of the court for consideration in relation to costs after the court has pronounced judgment on all other issues in this proceeding. We remind you that we act only for Fraser Health Authority. We do not represent or protect your rights, interests in any way. We urge you to obtain independent legal representation. There's that slap in the face again, because they know you're not going to fucking get it. And when you do, you get 30 minutes of it with some asshole sitting in there, humiliating you for the first 15 minutes and then trying to derail you from what you want to do in order to get Uncle John back ASAP. And justice. January 25th, 2018. See, it is our position, this is again from Andrew, it is our position that you are outside of time to file and serve your appeal. Section 14 of the Court of Appeal states in part. That's because they gave me the wrong date to come back and do whatever I needed to do, so that by the time I went back and did it, I guess I was 10 days late, because I should have been there on the 9th instead of on the 19th. That was coming through the direction of the people that were working in the appeal office, people. Just like they were telling me that I could write 7 pages and that I had to write 7 pages, then it turned into 3 pages, and then those 3 pages the judge didn't even look at. Okay? But yet Andrew, right? Andrew the Dragon, he came in with this. That's what he came in with. I came in with 3 pages with a small font. Right? That's a joke. Stonewalling. This is a great title for this video. What was I reading? Now I lost it. I think it was this one. The time limit for bringing an appeal or an application for leave to appeal is 30 days commencing on the day after the order appealed from is pronounced. An appeal or application for leave of an appeal is brought by filing a notice of appeal or notice of, because I had to get that waiver of fees before I could put the application and go in front go in front of a 3-panel judge, right? Because that's what you do, right? You put an application in to go in front of a 3-panel judge, which is an appeal. So before I could do that, I either had to pay $200 cash, and then I would have filled out that paperwork, served Andrew, and then would have stood in front of 3 judges. Okay? But because I didn't want to pay out another $200, I didn't really have the money at the time, I decided to do the waiver of fees. But they took that opportunity, people, to stonewall, turn it into another little mini fucking trial, and dismissed it, and said I wasn't worthy of going in front of a 3-panel judge under an appeal application. And that's how all the dates got all fucked up. The order of Justice Bowden was made December 7, 2017. By calculation, in order to approximately bring an appeal, the above rule required you to file and serve the notice of appeal by January 8th. We were not served with the notice of appeal until January 19th. If you intend to pursue this appeal, we will require you to obtain an order granting you an extension of time to bring your appeal. We will oppose any such application. We also intend to oppose your no-fee application, which you have reset for February 28, 2018. Because remember, I couldn't go in front of an appeal and in front of appeal judges until I got the waiver first. I had to get the waiver first before I could go in front of. Okay, so that's like, right? That's why we're like almost a month and a half late now, right? We will file and serve our response materials to that application in due course. And that's what they did. That was their application. Mine was reduced down to 3 pages. That was completely ignored. And the only reason the judge finally did acknowledge me was because as he was trying to dismiss it, that's when I started citing all the legislation on a provincial level, which he basically ignored. And then I could see that he wasn't paying attention to that. That's when I started listing all the criminal code infractions, right? And that's when he got flustered, got red in the fucking face, called a little break, had me come back in after he had the sheriff chasing me around in the halls, right? Because I was like, roll this down, and I was doing a Denny Craig. He didn't fucking like it, so he had to put me in check with his sheriffs. And then when I went back in, that's when he said, take it to the cops. I don't even think I have paperwork on that, people. I never went back. Shimei died. Well, she didn't die. I went in to go do the appeal process. You just heard what happened with that one. And then Shimei died. We are not your lawyer. We do not represent or protect your rights or interests in any way. But the minute I get sick, they're going to put their grubby fucking hands on me, and they're going to fucking do something to my body, because that is the history of Fraser Health Authority and their staff, right along with the rest of the health authorities, I'm sure, being that Uncle John was medically kidnapped and held captive for 4 months at the Victoria General Hospital in British Columbia, Canada. And we've got tens of thousands of old people right now under lock and key throughout each and every health authority across this province that are being basically treated, if not worse, than what Uncle John was going through. With no voice, people. With no voice. With no witnesses as to these families seeing how their loved ones are being treated. So yeah, I am going to take mine. There's more. I'm not even going to worry about it right now. Here's that fakey okie dokie. You sign here, I'll sign there. Oops, you made a mistake. Let me hit you up in the library. And you can correct the mistake, and we'll just kind of ignore it and never put it in the fucking file. But at least I got a copy of that. I found, basically, I know the librarian would give me a copy of this, right? Because she gave me something else that I was doing there. When last time I went, she gave me a book to look at to fill out the forms and stuff. But anyway, here is the, not that. I don't know if they're all here. I think so. So I'm going to bring that with me. Because if anything, what this is doing is it's jogging my memory. And it's reinforcing the fact that once we get to the end of that road in the Supreme Court and whatever dragon shows up is successful at knocking it out of court, then I know in my head, I'll remember I've only got 30 days to put that application in for a waiver, but maybe I might just fuck the waiver and pay the $200 to be able to go in front of a 3-panel judge. Okay? Because that's where they got me. Because otherwise, if I would have paid the $200, I would have just shown up and there would have been 3 judges. And of course, we know Andrew's trying to convince all 3 of them to chuck it out of court before it even goes to fucking trial. I would have had a better chance of succeeding for it to go to trial if I just would have paid the $200. But then it's like a money pit, right? Like everything you're seeing here is a fucking money pit. And they know it. The poorer you are, the bigger the money pit, right? And, you know, it all boils down to that manufactured poverty based around prejudice, bias, pompous individuals that are the predator class within our society that like to keep the wealth for themselves, and that's about it. And then I have a few forms here. Not many. I'm just going to bring it with me. I'll try and bring what's pertinent. I have a forms list. I seen it and now I can't find it. I should probably try and print it out off the internet. I just seen it today. I think it's in War Room 1. If I can just have the list, it will be easier for me to figure out what forms I need, right? And as I'm going through this all, start familiarizing myself with these court rules. I'll bring a highlighter with me. Right? And I'm pretty sure I'll be able to figure out. What I need to do tomorrow. Like I said, I'm not going to worry about document lists at this point. Right? I mean, I can submit a couple of them, I suppose, but, you know, there needs to be, you know, more attention paid to this in terms of, like, an impartial judge taking the time to really see what's being passed around. You know what I'm saying? See, this is where it starts to get heavy. So this is another reason why I'm like, how much evidence do you really want, Your Honor? Because, you know, it'd be better to be a little more specific, especially if the government gets involved and wants to pull up those files, right? Because that's where you're going to get a lot more information that's going to help to connect those dots through the whole thing, right? And yeah, here's forms, notes, just amended pleadings, right? So, I don't know. It all starts to look the same after a while, so I don't want to confuse myself too much, right? Like, it all starts to, you know, it's just, it's hard. But it's just something I have to do, people. And if I have to, I'll do it again. As I get sicker and sicker from the stress of it. Right? Yeah. So, there you go. Look at that. That's what I'm going to take. Now, whether I walk to the SkyTrain and carry it on my shoulder, or whether I take a taxi, I don't know, because that's a lot of paper, and I'll probably grab a few more things yet. And then I'm just going to sort it out at the courthouse and see if I can just figure out what that 35-day pleading period is all about. Right? Because I'm pretty sure I have to make my move and fill something out, register it, and then they'll come back with their case conference. It won't be a trial, it will be a case conference. They'll bypass the trial, turn it into a case conference for the purpose to dismiss it, have the judge dismiss it. But you see, the first time around, if you go in asking for the trial, they have to give you that freebie to do the amendment. Right? But my papers aren't quite as organized as I'd like them to be. And this is all I have to draw on right now. Okay. More evidence. I guess this is the laughing point in the university. Anyway, the law courts downtown on July 27th, 2020, they wrote me a letter and they said, "Dear Judy Lynn Chorney, I write to let you know that Professor Christy Ford from the University of British Columbia requested access to some materials in the court record on your file, Chorney versus Fraser Health Authority," and then it has, I think this is the appeal. This is not the official first notice of civil claim. This is an appeal number because it goes CA, right? Do you see that? Right there. Okay. Court of Appeal. It says right there. Court of Appeal. Duh. The Court of Appeal recognizes the importance, there's that slap in the face again, people, of the court. Okay, the Court of Appeal recognizes the importance of the open court principle in a democratic society. Openness ensures that members of the public can understand and comment on how the court operates and how proceedings are conducted. It also makes it possible to uphold the principle that the law applies equally to everyone. As a result, the Court of Appeal's access policy, which I was denied, which can be found on the court's website, generally permits members of the public who request access to court records to view the contents of those records. Professor Ford is researching the no-fee application. There's that slap in the face, people. Process at the Court of Appeal, and is interested in making recommendations to improve what? To improve not letting people have their fees waived, because you can simply come in and do what Andrew the Dragon did and the judge just sends you to the cops. Like, there's nothing there. Oh, maybe it is. I'll let you know. I'm going to sort that all out tomorrow. I can't find CIBC's. It's in a plastic bag. It's about this thick. I don't know where it is. Maybe I stuck it in a bin and then I took the bin downstairs. So now I'm going to be looking through bins with Andre's papers and other papers and more papers. Professor Ford is researching the no-fee application process at the Court of Appeal and is interested in making recommendations to improve, streamline, or change that process. She requested access to some materials in your court record as part of her project. Yeah, I'm just a project for these people. Chief Justice Bowman, didn't spell his name right, I don't think, approved the request after reviewing the purpose that was a different judge. I seen 3 different judges. I went in front of 3 different judges 3 different times. So tomorrow I'll pay attention. There's Master Taylor. He was the one who gave me the freebie. And then there was, I thought his name was Bowman, but they got Bowman here too. But this guy was the 3rd guy. This was the no-fee guy. It was a different judge. Unless maybe I wasn't paying attention because of my eyesight. I don't know. I'll have to double check that. I can't remember right now the second guy's name. I already forgot. I'm tired. I thought it was Bowman. But here it's spelt different. Chief Justice Bowman approved the request after reviewing the purpose of the project and details about how the request information would be stored and used. So in other words, he denied me, but he allowed her to access the files and she could do whatever she wanted with them, basically. Whereas I don't even think I ever got a letter from the courthouse people saying that the file has been closed. Well, I guess, or anything. I suppose I'm supposed to go there and go get it. I just didn't make it back. Not yet, anyway. Professor Ford, or a research assistant in her group, may contact you, well, as if they'd contact me, right, to ask you some questions about your experience with the no-fee application process. Well, we know it was just a bunch of stonewalling, the purpose of this video. It wouldn't have mattered, people, if I had it submitted in on the 8th of January, like they so-called wanted, even though they were running me around and misleading me down the garden path through the appeal office where you actually put your paperwork in, and that's why it kind of got pushed, right, like that. There was issues going on. I don't know what those issues are now. I can't remember, but there was just issues in terms of they were backed up or something. Something was backed up in there, and they were giving me the wrong dates. You are in no way obligated to participate in the interview, but we wanted to inform you in advance that you may be contacted for an interview in case you wish to participate. Well, I doubt this individual advocates on behalf of those that are below a certain income level, because nobody contacted me. So that's evidence, people. They took my case, they used it to build in bigger walls. That's what they did. Okay? It clearly says no no, right? I went in. The judge should have looked at my income. Said, yeah, clearly you're poor. Okay, we waived the fees. Then I had everything in the works to go fill out the application for that 3-panel appeal judge system thing. You know, going in front of 3 judges under an appeal. And I was appealing because I wanted to go to trial. I wanted to bring all this kind of stuff to trial. I just didn't know how to do it yet. So this pile is getting bigger and bigger, and now I'm thinking what I'm gonna put it in terms of being able to carry it. That's the best I can do right now, people.